be underway. And welcome to those who've just joined us. Look, please let me know if you can't see or hear me. I hope all is going smoothly so far. So look, I'm going to kick off. We've got a lot to get through today. So welcome to this webinar for small businesses in the NDIS sector. I'll start off with an acknowledgement of country. We acknowledge that the land we meet on here today is the traditional land of the Kaurna people. We acknowledge them as custodians of the Adelaide region and respect their spiritual and cultural relationship with their country. And we pay our respects to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today. So look, today we're going to be covering some common issues that we see here at the Working Women Centre from NDIS workers. So we're going to be looking at the SHADS Award and recent changes. We're going to be looking at how you can help to keep your workers safe, and as well as covering off on some common issues you might come across as an employer, like how to do fair disciplinary processes, or if you need to dismiss an employee, how to do that going to cause risk to your business. And finally, we'll just be having a little look at workplace equity and respect. So yeah, this presentation is general advice, obviously. And yeah, I hope that this gives you a good overview of what we'll be discussing here today. And certainly seek further advice if you need to. So I just wanted to check, can everyone see and hear me okay? There should be a chat function that you could type a message into. Can anyone type a message in and just let me know? Oh, great, thank you, Andy. Thank you, Chris. Appreciate that. Look, I'll keep going then, but please do shout out at any point if you do have any issues with the technology, or if you have any questions. I'll do my best to multitask and answer those as we go. So firstly, just a bit about the Working Women's Centre. I'm a lawyer here. I've been here for nearly 3 years, or actually more than 3 years. And we're really here to provide free and confidential advice to women and vulnerable workers who aren't members of a union. But we're also funded to provide free advice sessions like this one to small business employers about federal workplace laws. So we like to try and conduct these webinars to kind of help employers help their workers and try and prevent some of the issues that we see from workers who give us a call here at the centre. So a lot of the work we do is providing legal advice on workplace issues like wage theft, unlawful dismissals, discrimination and sexual harassment. We also do some advocacy work where I'm trying to research and lobby Parliament, etc., to change laws and benefit workers, or undertaking project work to add to the body of research that's out there. And we also do education as well, so sessions like this, and we also have a workplace trainer who can provide training sessions to your business on certain topics to help you have the best workplace possible for your workers. So that's a bit about us. And look, moving on to the issues we see from workers in the NDIS sector. There's a lot. I think the award to date has been quite complicated, so it's no surprise there that there's been some issues there and misunderstandings between workers and employers. The other issue, that we see, it might be to do with worker safety, for instance, providing a safe workplace for your employees, especially when they're going into clients' homes. And those award issues are around the minimum shift length, which level of the award is appropriate to pay your employees at, travelling time, unpaid admin time, or situations where a worker might not think they're paid properly for overtime or overnight situations. So without further ado, I'm going to jump right into the SHADS Award and go through some of the recent changes. So the SHADS Award, or the Social Community Home Care and Disability Services Industry Award, which is its long mouthful of a name. It was recently reviewed by the Fair Work Commission. So the Fair Work Commission concluded that some changes were needed to ensure that the award, together with the National Employment Standards, provided a fair and relevant minimum safety net of terms and conditions for workers in the sector. So there are several changes that came in from 1st of July 2022, and those were a review of part-time hours, a new minimum payment for part-time and casual employees, some changes to the allowances payable for laundry or damaged clothes, broken shifts, changes to the minimum shifts there, remote work and on-call payments and allowances, and changes to how a worker should be paid if there's a last-minute client cancellation. So, and overtime as well. So, look, there is a lot to get through today, and I don't want to rush because I know it is quite complicated, but I'll do my best to kind of highlight the changes that have been made. And of course, there's always further information on the Fair Work Ombudsman site if you need to go and have a look after the session. And as well, this session will be recorded. So if you miss something, I'll send out the recording. You can always go back and have a listen. So first of all, hopefully you know where to find the award. That's helpful, isn't it? So it's on the Fair Work Ombudsman site. You can literally Google SHADS Award if you like, and it should pop up. The address is there. So the full award is there with all the different clauses, and there's also pay guides and summaries as well to help you easily interpret the award. So yeah, I'm not sure if you're able, you might like to have a look on your personal device at the award as we're going through, and I'm going to be referring to different clauses of the award as we go. So yeah, check it out if you haven't already, because certainly it's it's the source, isn't it, of what you need to pay and give their conditions to your workers. So firstly, the minimum payment periods. So these have changed. It was 1 hour was the minimum shift length for many workers, but it's now changed. So for part-time and casual employees, they need to be paid for the following minimum number of hours for each shift or period of work in a broken shift. So for social and community services employees, except when doing disability services work, the minimum shift length is 3 hours. For social and community services employees doing disability services work, it's 2 hours, and for all other employees under the SHADS award, it's 2 hours. So disability workers fall under that 2 hour minimum payment period. So when we're talking about this, it's obviously it might only take your worker an hour and a half to care for a client, but you need to pay them that minimum shift length of 2 hours. So casual home care employees, it's also increased from 1 hour to 2 hours. So it's a pretty big change, and obviously I think a lot of employers out there are having to struggle with that change a bit, and in terms of their business and how to charge clients appropriately and whatnot. But this is the law now from the 1st of July 2022. We will go through some ways as well in which you can perhaps review your practices and how you might be able to incorporate that change. So just an example here. So Jo sees her first client, Amir, for 1 hour. She then drives 10 minutes to her second client, Pat, and then she spends a further 40 minutes caring for Pat. So because she has spent time traveling during that minimum payment period of 2 hours, she's paid for that travel time. And she's also paid for the period of work completed. So I think there's a bit of a typo there on my slide. So although her shift length is only 1 hour and 50 minutes, she does need to get paid for that 2 hours of work, including that travel time. And on a side note as well, often there'll be client case notes to take down or admin work to do after that physical duties of caring for the client, and that also obviously should be included in the paid time for that worker. So when we're talking about this minimum shift length, it's for each instance of work. So if you have an employee doing a broken shift, like working in the morning and then working in the afternoon, they need to be paid that minimum period for each instance of work. So under the award, a broken shift is a shift that is broken into 2 or 3 parts by an unpaid break or breaks in a 12-hour period. So for example, that minimum 2-hour payment applies to each shift. You can only schedule a worker to work a shift with one unpaid break, which doesn't include a meal break. It's an unpaid break in those 2 separate shifts and periods of work. You can ask a worker to have more than 2 unpaid breaks, but you need to negotiate with them. So you can't direct them to do a shift that's like within 12 hours. That's chopped up into 3 separate chunks. You can ask them if they're fine with that, and if they're fine, that's great. But you can't direct them. You can't schedule them to do that kind of shift and assume that they agree. And you also need to pay your worker a broken shift allowance. So under clause 20.12 of the award, if the employee is required to work a broken shift with one unpaid break, so for instance, working in the morning and then working in the afternoon, they need to be paid an allowance of 1.7% of the standard rate, which works out to $18.34 per broken shift, so per 12 hours. And if you've asked them to work 3 separate periods in that 12 hours, so they've got 2 unpaid breaks and they've agreed, they need to be paid an allowance of 2.25%, which is $24.27 of the standard rate per broken shift. So when we're talking about the standard rate, it's in the award. It's a bit complicated, but it's the amount you need to figure out there. Remember is that 1834 or 24.27. So that's standard no matter what level the employee's at. So just an example of the payment of broken shifts. So Rachel's working from 8 a.m. to 9 a.m. with one client, and then she will be working from 1 p.m. to 3 p.m. with her second client of the day. So although she only worked for 1 hour in the morning, she needs to be paid that 2-hour minimum payment for each of those shifts. So she needs to be paid 4 hours in total. So 2 hours in the morning, and then she's already working 2 hours in the afternoon. As well as that, she needs to be paid the broken shift allowance of $18.34 as her broken shift has 1 unpaid break. So look, it is can be a little bit complicated, but there is guidance, like I mentioned, on the Fergal Odmanson site if you need to review this as well. Cancellation. So obviously, it does happen when a client calls up and doesn't wish to have their services. So under the award, a client cancellation is defined when a client cancels a scheduled home care or disability service within 7 days of the service, and where a full-time or part-time employee was rostered to provide that service. So it also includes when they're rescheduling a service. So previously, under the award, as long as you told your employee about the cancelled service by 5 p.m. the day prior, you did need to make a payment to them. However, now there's you will need to pay them under the following criteria. So if your client cancels or reschedules a service with 12 hours notice or less, you either need to find your worker other duties to do during that scheduled time, or you can cancel their shift, but you must pay them what they would have earned for that shift. And if the client gives more than 12 hours notice, you can direct the employee to work what is called make-up time. So we'll go into that. So make-up time, it's basically offering your employee the opportunity to do a different shift at a different time to make up for the cancelled service. So for you to be able to direct your employee to do this, the client needs to have given at least 12 notice hours of the cancelled shift. You need to consult with your workers. You do need to speak with them and get their agreements. You can't just direct them to work a different time in a different shift. You need to give them 7 days notice of this new makeup shift, or less with negotiation with your employee. This makeup shift needs to be worked within 6 weeks of the cancelled shift. It can be with a different client or the same client, and it can be a different type of work as well. But if they're doing work at a higher level under the award, then you need to pay them that higher rate. So following on to an example here. So Tin is a part-time worker, and he's scheduled to work with his client Ben at 8 a.m. on Wednesday and 12 p.m. on a Friday. On Tuesday night, Ben calls you and cancels the services for the week. So because you can't Tin more than 12 hours notice of the cancellation of that Wednesday morning shift, you either need to find Tin other work to perform at 8 a.m. on Wednesday, or you can pay him for that cancelled shift. So as it happens, Tin has some admin work to do, so you direct him to do that work at 8 a.m. instead of going to care for Ben. However, if you didn't have that work, you would have to pay him for that cancelled shift. With regard to the Friday 12 o'clock shift, you ask Tin if he'd like to make up that Friday shift on the next Friday, and Tin agrees. He's fine with that. So because that's more than 10 days notice, 7 days notice, that's fine. You can direct him to do that makeup shift on the following Friday. So again, a little bit complicated, but I think if you step through it, it does make sense. Okay, so on-call and remote work. New minimum payment periods apply as well to on-call and remote work. So remote work, and I guess that's identifying when an employee is either on call, or perhaps for some reason you need to call them outside of their work hours to require them to do some work, or perhaps ask them a question about a client or that kind of thing. So remote work is now defined to mean work that is not part of an employee's ordinary hours, and which is not required to be performed at a designated workplace. So it's not overtime. It's not asking an employee to work longer than their scheduled shift. It's really when they're on call, or when they're perhaps working from home. So employees who are on call and who must perform work away from their designated workplace will receive a minimum payment of 15 or 30 minutes, depending on the time of day the work is being performed. So if they're on call and you need them to perform work between 6 a.m. and 10 p.m., they get 15 minutes pay minimum. And if it's overnight between 10 p.m. and 6 a.m., it's 30 minutes pay minimum. So, and employees who aren't on call, so they're not rostered to be on call, but they are required to do remote work, will be entitled to 1 hour's pay. So, yeah, again, new minimum payments periods for that kind of work. And remember that regular penalty and overtime rates apply. So if this work is occurring on the weekend or a public holiday, those relevant penalty rates would apply as well. So another example here of on-call work. So Kira is a part-time disability services support worker. You call Kira and ask her to be on call for the following day between 12 p.m. and 12 a.m. So firstly, she's entitled to the on-call allowance, which is separately already existing in the award. At 3 o'clock on Wednesday, Kira gets a call from another care worker at a client's home, and Kira provides some assistance to that worker over the phone for 10 minutes. So that call is paid at Kira's minimum hourly rate because it occurred between 6 a.m. and 8 p.m. And although it only takes 10 minutes, she needs to be paid that new minimum period of 15 minutes. So later in the day, in the evening rather, at 10 p.m, Katie receives a call about a different client, and that job takes 45 minutes. As that job was between the hours of 10 p.m. and 6 a.m, which is outside the regular span of hours, it will be paid at 150% of her normal rate, so the overtime rates are applying. And it does meet that minimum 30-minute payment that we spoke about earlier. So again, it's just being conscious of those different rates and conscious of when the work is occurring. So if an employee is on call, you can ask them to keep a timesheet to evidence that the times that they are working to help you figure out when they should be paid. Okay, so a small change as well to 24-hour care and sleepovers. So there's been some changes to the facilities that need to be provided to employees when they're undertaking that kind of work. So employees who do those kind of shifts, the award now says that they will be provided with a separate room with a bed and clean linen, and the use of appropriate facilities such as access to food prep facilities and staff facilities where those exist. So just thought I'd mention that one as well. Okay, so yeah, I do apologize for rushing through these changes. I know they're all quite big changes in themselves, but I'm really hoping just to highlight these to you today so that you can go away and do further research on them if you need to. But next, I wanted to move on to another common issue we see under the SHADS award, and that's when an employee brings us and says, I don't think I'm being paid at the right level of the award. So if you go to the FERC Ombudsman site and have a look at the award, at the schedule, so at the very end of the award, there's a list of classifications which detail the level of duties that, or rather the duties that an employee undertakes at each level of the award. So when you're hiring an employee, obviously make sure that the duties you're asking them to do match up with the level you're paying them at the award. And remember to review it regularly. Like often as an employee becomes more experienced in the role, they may start naturally undertaking a higher level of duties as you trust them and their ability and their experience. It's really important to go back and make sure they're getting paid at the right level of the award for the work that they're doing, because otherwise they may come back at you with an underpayment claim at some point in the future. And another common one is progression between pay points. So this one often gets missed at clause 13.3. So the award says that after being employed for 12 months continuously, an employee is eligible for progression from one pay point within a level to the next if they have demonstrated competency and satisfactory performance over those 12 months. So often, often we'll see a client bring us who has been at the same level, the same pay point for a number of years, and that progression has gotten skipped. So just be mindful as well of the anniversaries of employment of your employees, and check the award and consider whether you do need to move them up to the next level that they're being paid at. Okay, so I am an employment lawyer. I am not an NDIS expert or an expert in providing client care. So obviously, please do seek further advice around how to incorporate these new changes into your business. But if you're thinking about how to make these changes in paying your employees, how to manage that within your business, just a few tips here. So firstly, you do need to gain the consent of the clients relating to any changes that affect them. So I understand that under aged care law and Australian consumer law, you can't make changes to home care agreements or individualised budgets or care plans without informed consent and agreement from your care recipients. You also need to consult with your employees about the changes that might impact them, for instance, changes to rostering. So aside from these changes to the award, there's always been these consultation requirements in the award, which says that any major workplace change, which can be change to regular hours or change of location of work, awards often say that you must consult with your employees, and that obviously means, in the plain sense of a word, informing them about what you're thinking of changing, seeking their feedback, and then taking that into consideration, but before you make a final decision. So that in itself can be a breach of the award if you fail to consult with an employee. So again, not being an expert in the NDIS sector, but you might be able to make changes to the scheduling or rostering arrangements you have. You might be able to include other work activities in those minimum shift times. So again, like often a complaint we'll hear from employees here is that they are scheduled to do the care work at a client's home, but then they're expected to do the case notes and admin work in their own time. That time should be paid. So perhaps that work can be included in that minimum payment period. And of course, you may need to make reasonable adjustments to your pricing structures where justified. I also just wanted to touch on what to do if there's been some alarm bells going off and you realize perhaps you haven't paid any of your employees properly, or you've missed some of these changes in the award. So look, it happens, and obviously if you're here today or you're listening to this recording, you're already being a conscientious employer trying to do your best by your employees, and mistakes happen. So if you make a mistake, obviously notify your employees and calculate how much you might have underpaid them, and then you can negotiate with your employee to pay them that back payment. So it's just important if you identify a mistake to obviously be upfront and prompt by identifying that mistake to your employee and then rectifying it. So look, mistakes happen, and the Employment Tribunal and everyone realizes that, but as long as you can show that you've done your best to interpret the award fairly, and that if you've realized a mistake, you take prompt action to rectify it, then you should stay out of trouble. So moving on to other obligations you have as an employer. So really starting to talk about providing a safe workplace for your employees and providing an equal and respectful place for your workers to work in. So I'll be kind of relating these ideas back to your obligations under the Fair Work Act and under federal and state discrimination laws. So kind of looking at what your obligations are and then what your risks are as a business if you don't uphold those obligations, and your employees what your employees' legal options are to make a claim against you. So firstly, you have the fundamental obligation as an employer to keep your workers safe. You have to do what is reasonably practicable to ensure the health and safety of your workers in any workplace, whether that's in your office or at a client's home. And conversely, workers also have a duty of care to reasonably take care of their own health and safety by not negatively affecting the health and safety of others around them, and by complying with any procedures and policies and instructions that you put in place. So in terms of reasonable instructions in the NDIS space, it may include following reasonable instructions relating to the delivery of a care plan and only undertaking activities that have been agreed to in a client service agreement, like wearing personal protective equipment, like gloves and masks, etc., and so forth. So how do you do that? Again, I'm not an expert in the provision of client care and all the checks and balances that you need to make sure you've done in terms of providing the best and safest care to your client. But I'm just going to cover, kind of generally speaking, how you can make sure that you've got some appropriate checks and controls in place. So you should conduct a risk assessment in a client's home before you send an employee there. Identify potential hazards and put appropriate controls in place. And again, generally speaking, the key to any risk management process of a workplace is to document things, communicate them with your employees, make sure that your employees know where these, risk procedures or manuals are, and that they know how to complain to you if they need to about an unsafe work condition. Review your policies regularly and review the workplaces regularly for further risks. And then continuously consult with your employee as well. So make sure that you have an open feedback loop with them. They should feel comfortable coming to you at any time with a complaint about their safety. So make sure that you're checking in with them and that you're really hearing any concerns that they may have. Make sure that they know that if they come to you, that you will take it seriously. So I've just got a little diagram there that I have taken from an excellent guide put out by Workplace Health and Safety in Queensland, a guide to work in people's homes. So as you can see, step 1, identify hazards. Step 2, assess risks. Step 3, control those risks, and then keep reviewing those control measures and consulting all the time. So, sorry, I'll go back one more thing. Yeah, and ensure that your workers have appropriate training with how to deal with those risks. Like I said, make sure that they know from day one of the job how to report issues or complaints, because obviously something's unsafe happening at work. It's natural to be in a bit of a panic and not quite know what to do. So make sure they've got that knowledge straight away about their first steps to take to keep themselves safe. And another good point is trying to facilitate connections between colleagues as well. So it can be quite an isolated job for a care worker going out to individual clients' homes, but it's a really good idea to be able to bring your workers together along with yourself and make sure that they know that they have the support of their colleagues as well, and that they are part of one workplace to share common concerns and tips. So look, I also wanted to touch on workplace violence and sexual harassment. Again, that's a really big issue that we see from workers in the centre who have been subject to unsafe work conditions. So, because in your sector, obviously, there's risks involved to workers when they're dealing with clients with challenging behaviours, for instance, in an isolated workplace like a client's home. So workplace violence is defined as any incident where a person is abused, threatened, or assaulted in the course of their employment. And those risks of workplace violence occurring are increased when the worker doesn't have knowledge about what the risks are, like they haven't had the care plans or information about the client communicated to them properly, so they don't know what to expect from the client in terms of behaviour, and they don't know how what the client's triggers are. Risks are increased with the frequency or severity of those behaviours and the incidences of those behaviours. So obviously you'd have a different risk profile in place for a client that display these behaviours all the time, as opposed to it's very hard to prevent against a one-off incident. And risk can be increased as well in the physical environment. So even like the layout of the house, so they being asked to care for a client in a confined space, or perhaps in a space where there might be unsafe tools around, like knives in the kitchen or something like that, if they're isolated in that space. So have a look at their physical environment as well. There we go. So what are the controls? How can you try to put controls in place to manage these risks? Again, you probably know more about this than me in terms of caring for your clients and the care plans involved, etc. But identify the behavioural expectations with the client. How do you expect them to behave? Consider modifying the environment. Definitely make sure you communicate all the relevant information to your workers, again, from day one, before you even send them out there. Make sure they have all the information about the client, as well as how to immediately escalate any concerns. And a big one is consider whether you really need to be sending two workers to a place rather than sending them there alone. We've had some cases here where clients have been sent into unsafe situations, and look, really, it should have been a two-person job either to avoid physical injury. Like I had one client who was asked to unsafely lift a client on her own. Really, it was a two-person, two people needed to be there for that client, or whether it's in terms of the client's behavior, like for instance, sexual harassment from the client. So for instance, a personal dress might be a good option as well. So again, there's a lot of material out there about how to control those risks, but those are just a few ideas. I also wanted to cover sexual harassment. Like I said, it's a big issue out there, not just in your sector, but generally for workers. And here at the Working Women's Centre, we are strategically focused on preventing sexual harassment in the workplace. So we actually just have received some new funding to specifically focus on sexual harassment legal casework for workers. So obviously we're here for workers who need our advice and representation, but also really want to make sure that we're getting the message out there to employers. So sexual harassment can be between colleagues, or it could be perpetrated by a client against a worker. But when we're talking about sexual harassment, we're talking about unwelcome conduct that's sexual in nature, that is unsolicited, unlawful. It's often repeated, and it's behaviour that disturbs, offends, intimidates a person, and often, of course, it makes work difficult or impossible. I just really wanted to draw your attention to changes to the law that are occurring. So they're still before Parliament as we speak. There may be further amendments, but really the federal government is pushing for changes to the laws to protect workers from sexual harassment in the workplace. So there's a proposed amendment to the Anti-Discrimination and Human Rights, the Respect at Work Bill, which will be amending the Sex Discrimination Act. So it's introducing a positive duty on employers to take reasonable and proportionate measures to eliminate unlawful sex discrimination, including sexual harassment. And they're also beefing up the Fair Work Act by specifically prohibiting sexual harassment of workers, people seeking to become workers, and as well as people who are in a workplace conducting business or undertakings. So the Fair Work Commission will have new powers to deal with those kind of complaints from workers as well. I just want to talk a bit about this positive duty on employers. It's really, employers are really going to need to proactively put procedures and policies in place to protect their workers. It's not going to be enough anymore to react when an employee comes to you with a complaint. You need to show how you've actively tried to prevent the harassment occurring in the first place. So this is probably an example of where sexual harassment occurs from perhaps one employee of yours to against another employee. But in that instance, if you haven't proactively prevented that harassment by having appropriate procedures and policies in place, or ignoring a complaint, for instance, you can be vicariously liable for the actions of that employee that perpetrated the sexual harassment. So yeah, if you can prove that you've taken all reasonable steps to prevent the harassment occurring, then you won't be vicariously liable. So the last point there about costs is just saying that the change, in very high level summary, changes to the laws mean that if an employee makes a complaint of sexual harassment against you from having it occur in the workplace, as it goes its way through courts, the courts can actually award costs against you as well, whereas at the moment it's each party bears their own costs. So it really is going to be a something you should consider about whether you have a sexual harassment policy in your workplace, and if you don't, then taking steps to put one in place. So in the worst case scenario that something does happen, you can show that you've got a policy and that you've communicated it to your employees. And certainly if you receive a complaint about a worker's safety, that you've taken it seriously and acted appropriately. Just to really prove the point, I guess, I wanted to draw your attention to a case that's currently in the media. So SA Support Services is a disability support service, and they've been sued by Safe Work SA because one of their workers was sexually assaulted by a client. So you can read all about it on the ABC News website. But in summary, the worker was sexually assaulted by a client back in 2020. Safe Work SA launched legal action against them in the South Australian Employment Tribunal, alleging that it failed to protect the support worker from being abused. So there was criminal implications for that male client who perpetrated the assault. He was sentenced to 3 years in prison as he pleaded guilty. And that's even despite the fact that he had a serious intellectual disability. So yeah, he received just punishment for that. But in terms of the disability provider, the latest update is that they've pleaded guilty to failing to provide a safe system at work. So they've admitted that they did not give the worker adequate information about the risk that client posed, and they did not perform an adequate risk assessment of that client. So in this particular case, SA Support Services were aware that the client's inappropriate behaviours had been escalating. And for instance, it didn't have appropriate policies in place, like it didn't require its staff to wear a personal dress along. It didn't ensure that the worker was instructed to call for assistance in an unsafe situation like that. So yeah, so it's a very serious matter. It is still before a court, so it will be back before the tribunal later this month for the tribunal to judge the matter. But for this type of offence, maximum penalties can be from $500,000 to $3 million for a corporation, and from $50,000 to $600,000 for individuals. And it can also include imprisonment of up to 5 years for individuals if the offence is considered reckless conduct. So the maximum penalties are quite huge. And gosh, I mean, of course, like I said, it's the most awful situation, and you'd hope that would never happen. But the risk is certainly there, so it's certainly something to pay attention to and do what you can to prevent. So just going on to if the worst happens and your employee makes a claim against you because you haven't ensured a safe workplace for them, you know, what kind of claims could you be looking at? So in terms of sexual harassment, it could be a stop sexual harassment order in the Fair Work Commission, or they could lodge a complaint in the Human Rights Commission or the Equal Opportunity Commission. They could make a workers' compensation claim. So I do imagine in the case I just discussed that the worker likely would have had a successful workers' compensation claim as well because they've suffered an injury in the workplace. They can make a Safe Work SA complaint, which is obviously what happened there as well. And in terms of other claims an employee might have, it could be a general protections claim, which we'll go into in a minute, and separately, or an unfair dismissal claim if they're dismissed. So we'll go into both those claims in a little bit. And for those payment issues with the award and what they should be paid, they could file a claim in the South Australian Employment Tribunal, like a money claim, or a pecuniary penalties claim. So that's where they're alleging that not only did you underpay them by a certain amount, but you should also pay them. You should also be fined basically for breaching the award by not paying them properly. So I won't go into that one further here today. There will be more information out there for you if you need it. It's certainly something to be aware of. So just briefly wanted to touch on workers' compensation because of that case we just discussed. So in that case, injuries can be either physical or psychological injury. So if a worker is suffering an incident at work, they may develop depression, post-traumatic stress disorders, anxiety, etc. And in the case of those psychological injuries, work needs to have been the significant cause of those injuries. So again, just best practice, obviously, to make sure that you're really preventing that risk from occurring for your workers. But if you identify that risk, to make sure that they have the support they need. Okay, so wanting to move on to so I know I'm rushing through, but there's a lot to get through, and like I said, wanted to make sure that we're touching on all the important points here. So I just wanted to move on to other risks that you might face as a business, like how to fairly deal with complaints and disciplinary matters. So when we're talking about complaints, it might be a complaint from one employee about another employee. It might be a complaint from an employee about conditions at work, or feeling that they're not getting paid properly, for instance. Or it might be a complaint you receive from one of your care recipients about your employee. So the general principles apply to all those certain situations. So very fundamentally, you need to deal with that complaint in a fair and transparent way, and make sure that you are documenting all the steps you take to do that. So when we're talking about what is a fair kind of way to deal with a complaint, obviously you need to investigate that complaint and do it fairly. So you do have the obligation to maintain a safe workplace, and you need to weigh the risk between how are you managing this situation, what is the risk to your other workers, for instance. Timeliness is a big thing. Do it as soon as you can. And if it's a small workplace, like your workplaces might be, you might even need to assess whether it would be better and fairer to have an independent third party come in and conduct that investigation, so that there's no accusations of bias. If you need to remove an employee from the workplace, you should stand them down with pay while the investigation's taking place. Like if you do need to stand them down, it should be with pay. And you need to properly keep them informed of the steps. So, we've had clients call up in other industries as well, where they've been stood down and it's just seemingly an endless process. It's taking weeks. Timeliness is a big thing, but you need to be keeping them informed as well about what the next step is and when they can expect to hear an outcome. So once you've conducted the investigation and you feel like that you have a fair understanding of the facts and what occurred, you can decide on a fair and reasonable outcome. And again, make sure you take the time to properly communicate that outcome to your employee. So if the complaint is about the conduct of your employee, again, those other factors stand in terms of timeliness and independence, etc. But it's also very important to make sure that you properly communicate the allegations to them in sufficient enough detail that they can appropriately respond. So it's not enough to say, well, I've had a report that you've spoken to clients inappropriately, because they're not going to know which client or what day or how long ago it was. You need to say, on this date, we've had a report that this occurred and that you said this, so that way they have enough information to remember what you're talking about and respond and put forward their side of the story. So allow them enough time to do that. Often here, I want to know what's happened by 12 o'clock tomorrow, or even, called into a meeting and they're asked to respond on the spot. put it in writing and give them a few days to respond at least. Once you've got their response, really consider it genuinely. If you're perceived to have made up your mind about it before you've had their response, that can count against you in like an unfair dismissal claim, for instance. And again, just make sure that you can justify and explain whatever reasonable and appropriate outcome you come up with. Another really important point is you have to be careful not to adversely affect the employee who has made a complaint. So say, for instance, an employee comes to you and complains about feeling unsafe in a client's home. It's not appropriate for you to just cut their shifts then and not send them anymore, and so their pay for the week is down, because that is adverse action. So basically, employees in Australia have the right to make a complaint or inquiry about their employment. And if you take an adverse action against them, that's something called a general protections claim in the Fair Work Commission. So when we're saying adverse action, it can be, like I said, cutting their shifts. It could be dismissing an employee. It could be favouring one employee over another, discriminating against them when you're talking about hiring an employee. So there's a number of things, but just remember, if an employee comes to you with a complaint, make sure that they're not worse off from having made that complaint. Just a bit more information there briefly about general protections claims. So as you can see there, that the maximum penalty for a contravention, if it were to go all the way to court, is quite a lot of money. So again, I won't go into that further now, but just be conscious about treating your employees fairly if they do make a complaint. So if you've investigated a complaint and you feel that disciplinary action is necessary, again, be fair and transparent and make sure that you've documented everything. If you require the employee to attend a disciplinary meeting, make sure you've given them enough notice, and it should be during their work hours, not outside of work hours. Offer them a support person if they'd like one, someone to come along and help them take notes. As I said, give them specific details and provide them a reasonable opportunity to respond. So we've only got a few minutes left, so I do just want to make sure I've covered everything. Unfair dismissals. So really, that's where a dismissal is harsh, unjust, and unreasonable. As you're small businesses, the Small Business Dismissal Code is your friend. It's a document on the Fair Work Ombudsman site. You can follow that, and if you're following all the steps and you can show that you've done that, that will be a defence for you if an employee brings an unfair dismissal claim. So there's factors there that the Fair Work Commission would consider that would make a dismissal unfair. So that would make it harsh, unjust, and unreasonable, relating to whether there was a valid reason, whether they had enough notice to respond, and that kind of thing. So have a read about that on the Fair Work Commission site. Okay, so we're coming to the end, as I said, and I just really wanted to end on a kind of a positive note. I know we've gone into a lot of detail about legal claims and risks and terrible things that could happen, but really the fundamental thing about having a healthy and safe workplace is it's really up to you and how the way in which you conduct and interact with your employees, and the fundamental kind of beliefs of equity and respect that you display, that really has a huge impact on your staff. So fundamentally, if you have a happy and healthy workplace with open communication, in which employees feel safe with you coming to you about complaints or issues, then hopefully you're going to have much less trouble with all of the things we've talked about in terms of legal claims or disciplinary processes. So obviously it's very challenging to manage a bunch of people with different life histories and experiences and beliefs, and obviously such a complex workplace that you have in the NDIS sector, providing that care to workers with complex behaviours. But fundamentally, you're all there because you want to care and help people. So I really hope that today has helped you kind of take away some thoughts around how to conduct your business in a happy and healthy way for your employees. Just wanted to give a shout out to our next webinar, which is about domestic and family violence leave. You might like to tune into that one. There's been changes there about leave that your employees will be entitled to. And yeah, Working Women's Centre can also provide you with more training specific to your workplace on those things there, including reviewing your policies that you might like to put in place. So contact us for more information. We can consult on your workplace policies as well. So please do check out our website and follow us for more of these webinars. Look, I really hope that it's been a interesting and helpful session for you today. I will send out the recording in the next week or two as well if you'd like to review it with a feedback form. So please do fill that out as well. But look, I'll bring it to a close. So thank you so much for participating, and I hope you have a great rest of the day and best of luck with your businesses. Thanks very much.